Happy Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today, we're talking about possession of controlled substances. Cases that should have gone to the Supreme Court of Canada, but didn't. Mr. DuPont owned a farm, and police executed a search warrant on the farm, discovering a lot of drugs. As a result of the execution of the search warrant, Mr. DuPont was charged with possession for the purposes of trafficking and a number of other offenses. At trial, he argued that possession could not be proved because Mr. DuPont was not the only person with access to the farm. More importantly, he also had a farm laborer and other individuals who occupied various spaces around the farm in the course of their employment duties. The court ultimately ruled that Mr. DuPont was in possession of the drugs, and they determined this on the basis of the fact that it didn't make sense that a person would have a very valuable stash of drugs that they would just leave unattended on a property where other people had access to it. And Mr. DuPont appealed, sought leave to the Supreme Court of Canada, which was denied. This case raises very important issues about the doctrine of possession. In Canadian law, possession doesn't just mean that you actually are physically holding something. Possession can be constructive, meaning that it can be inferred that you possessed something based on your knowledge of the existence of the thing and your control over it or the space in which it is located. And so it didn't make sense that the farm laborer would have had possession of the drugs and not Mr. DuPont because he had knowledge of the space, control over it, and the farm laborer came and went from the property and wouldn't likely leave large amounts of drugs on the property without supervision. But of course, this to some extent neglects important issues about having access to space and control over space that you occupy as an employee or where your employer may not actually go. And constructive possession is one of the circumstances in Canadian law where circumstantial evidence is effectively used to prove very serious allegations. The Supreme Court of Canada has not weighed in on the doctrine of constructive possession for a very long period of time. And it is important to have these views from the Supreme Court of Canada continually refreshed so that this doctrine doesn't expand into ways that result in innocent people being convicted for the actions of other individuals. The decision as it stands opens the door to bad acting employees, take advantage of employers not paying attention to large pieces of property or large areas, or even their attending their workplaces on a regular basis, and allows employees essentially to use employers as patsies in these types of cases. This is something that the Supreme Court of Canada, I think, missed about Mr. DuPont's arguments and the significance of the way that the court interpreted this type of evidence. And it's unfortunate because likely this will lead to cases where innocent people end up charged with criminal offenses that they had no involvement in. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law Corporation. Thank you to Brazen Bull Creative for putting together these videos. Please like, subscribe, and share with your friends.